Make a brief introduction to the legal practice in China concerning the Singapore's convention. Yes, because it's currently working in the Beijing Handu law firms, which is we have the 27 offices around China, but my office is in Shanghai, so I would know more about the legal practice in Shanghai and Beijing. So I definitely will be introduces that the legal practice of the Singapore Convention in China. So let's start this. The first one is I have to talk about that the general introduction to the Singapore Mediations Convention in China, which is firstly that's on the 7th of October 2017 is actually China. The Ministry of the Foreign Affairs is Mr. Wang Yi actually on behalf of the Chinese the government have been signed that Singapore Convention. So which is from the national level, since China has already joined that conventions very in formal wise. So China's become the member states of the Singapore Convention. So for the Singapore Convention, the China's position, I mean the general positions from the national level is yes. The answer is yes. China has already been joined the Singapore Convention, but on the local levels, which means is that for the enforcement of that the treaty. That China needs, which means is the Singapore Conventions also need to be ratified by the Chinese, the People's Assembly. In China, the People's National Assembly is in charge of the ratifying that international treaty signed by the People's Republic of China. So currently, we have to wait further notice from the People's National Congress or National Assembly to make the further notice to be ratified that the Singapore Convention in China. From the local levels, including that Chinese law firm, Chinese court, and Chinese arbitration institution, we will still wait. We will still wait to know that whether the Singapore Conventions will be applied directly in the China mainland. So we have to wait for the notice, and will be take us not so many long time, but we have to wait quite a time for the notice. Currently, what I'm trying to say that there were so many the problems in China for the challenges concerning that Singapore Convention. The first question is from the levels of the legislation, because in China we have the national law, which is called the Chinese Arbitration Code, arbitration laws, ratified in the 1995. But until now, we don't have a national code concerning that mediation law, which means there was no any directives code or the code of the commerce or the commercial commerce, code of the commerce that governing that the commercial mediations in China. So this is the first question. And the second question is we don't have, in China, for the Chinese lawyer, we mainly rely on not only just the code or the legislation, but mainly rely on the judicial interpretation. Let me take a step a little bit. Let's explain a little bit. Because in China, there are so many the different levels of the legislation. We can see the legislation from the national level as well as from the local level. But more importantly, we have to rely on the national judicial interpretation, which is made by the Supreme Court of the Justice, as well as the local court. I mean, the highest, in Shanghai, we have the Shanghai highest court, which they also have the qualification to be issued that the judicial interpretation concerning that commercial mediation, particularly for those mediation agreement, whether they can be enforced direct in China, whether they can be recognized by the local court. This is a big problem. And the second, the third problem is for the relationships to dealing with the relationship, mutual relationship between the mediation and the arbitration. Because in China, in the past 30 years, we have already cultivated a great number of the independent arbitrators who actually work in the different arbitration institution in China, which you already know. Here we have Shanghai Arbitration Committee, Shanghai International Arbitration Center, as well as the CITEC, China International Arbitration Committee Center, which is based in Beijing. But currently, we don't have so many like the resources of like our own Chinese commercial mediating in China, which is the biggest problem for China, is lack of the independent mediator in China. So even we have already been signed the Singapore Convention, but the problem is very, very obviously, we don't have so many like the experts or the independent mediator to do that, the international, or we say transnational mediations between the Chinese client and the international client. And thirdly, this is the problem for China, is challenges for the enforcement, whether those is mediation agreement or conciliations mediation agreement can be recognized and enforced in the local court. Actually, until now, we don't have so many like the judicial documents as material now. So we will have to be wait and see and to see the problem. And thirdly is about the nature of the mediation itself. Because in China, we already know that this commercial mediation, arbitration, is mainly conducted in a confidential ways, which means is most of the documents as well the arbitration board should be kept it confidential. But what about this mediation? What about those mediation processes? Whether those documents or the final awards, mediation awards, should be opened to the public or not? Because in China, we actually have the mediation procedures, but which is only mediate those civil cases. But for those international commercial cases, whether we can open it to the public, at least to open to the court, this is a big issue. So currently, we don't have so many like get the direct answers on the local levels. No, we don't have it. Finally, I just want to introduce is that the problem for that the leading the trend in China, which we can see is very, very positive. Firstly, the Chinese government as well as the local authority have realized the importance of like firstly ratifying that Singapore Convention, and will take the further steps and to make the deeper understanding on this issue and try to fix this problem. The first question is WIPO, the International Intellectual Property Organizations, which is in 2019, actually by the joint efforts made by the Chinese government and WIPO in the Genevas, the WIPO Mediation and Arbitration Center actually established in China. And what is the best things for me is their offices is in my offices. We share the same building. So we're actually the neighbors with the WIPO Shanghai Center, the WIPO Arbitration and the Mediation Center, which allows us that WIPO can actually be doing the related mediation and arbitration business in China in the name of the WIPO itself, to which the WIPO, allowing the WIPO setting in China is a big, very positive signals for China's openness to the legal area and the legal services around the world. And finally is that in Shanghai, by the end of the 2020, we have formed a national institution, which is named the Shanghai International Dispute Settlement Center, which is already attracted both like very important the international arbitration center, mainly arbitration institutions based in Shanghai. Until now, those like ICC, International Chambers of the Commerce, as well as the Singapore Convention, Singapore SCIC, Singapore International Arbitration Center is also based in China. They have the offices in China. And so the Japanese and the Korea's arbitration institution have already joined the center. And I hope that in the future, more and more the chambers of the commerce, more and more, and the international arbitration institution, as well as mediation institution, including those the institutions from Italy and Europe, will also have their offices and some branches in China, in Shanghai as well. So thank you very much. This is my a very little ideas want to be shared with you. Thank you, Giovanni.